All right, so you have this really interesting case, so I'll let you introduce it, but I'm fascinated about this because I think we have a clearly unconstitutional challenge put up against President Trump. Okay, tech difficulties. There you go. We're good? Okay, so we start over live? All right, so we are here at CPAC Live 2025, and we've got a fantastic, really interesting constitutional challenge about something that's about to be heard at the United States Supreme Court, a challenge to President Trump's power of appointment and removal.
That's right.
But more specifically, removals. I'll let you explain.
Yeah, so you're exactly right. This is the first of these cases to make it to the Supreme Court. And the issue is the president fired the head of what's called the Office of Special Counsel. Gentleman's name is Hampton Dellinger, and he sued. And he wants his job back. He's suing for reinstatement. But there's a whole slew of problems with that. First of all, the president, this guy's a principal officer, so he reports directly to the president. And the president has the power to fire his subordinates, and that's in the Constitution. Mm-hmm. One of the ways we know that that power is absolute is that the Constitution gives all of the executive power to the president of the United States. So that's the first thing. It vests all that power in the president. Then the Constitution says, okay, when it comes to appointments, we're going to give the Senate a role. We're going to give them the advice and consent role.
Right.
But you'll notice there is no advice and consent role for the Senate when it comes to removing people from office. The president has that all on his lonesome. And the fact that the Constitution did that with the appointments power and left the removal power alone means that the removal power is absolute. And this isn't just me saying this. This isn't something that the Trump administration has come up with. James Madison said this way back, at the time. And furthermore, the Supreme Court has spoken to this recently in a couple of other cases. You may remember the head of the Consumer Financial Protection Bureau was fired, and President Trump, in his first administration, installed a new head of the CFPB. And there was this question about whether or not the head of the CFPB was protected. Congress, when they created the agency, had protected that office and said, well, you can't remove them unless there's some sort of malfeasance or they sort of these tenure protections around the role. Mm-hmm. And what the Supreme Court said in a case called Saylor Law is no. Those tenure protections for someone who is the single head, like the head of the CFPB is, the single head of an agency that reports directly to the president, he can fire that person. No tenure protections for them. Well, this is the exact same issue. The Office of Special Counsel is one guy heading one, the only person at the head of the agency. So
I don't see any distinction whatsoever.
There's really no distinction, no significant distinction, no material distinction that should matter for the legal outcome here. And so the fact that a District of DC judge, Amy Berman Jackson, saw fit to not only issue a temporary restraining order here, but to actually order that Dellinger be reinstated to the position, that's pretty unprecedented. A lot of folks are looking at that and saying, now, wait a minute, district judges don't even have the power to reinstate. It's not one of the so-called historical equitable powers that judges have. Mm-hmm. So if you look in history, there have been other people who have sued when they've been fired. This isn't the first time.
I would think that his recovery would be simply damages for lost wages.
You're absolutely on top of that. That's exactly right. And that's what people have done in the past. They've sued for damages. And you might say, well, look, I was appointed for 5 years. I have a right to this for 5 years.
Right. You have
I've
got 4
years left or whatever. So I'm going to sue for 4 years of salary.
Yeah.
That you could imagine the judge ruling on, but not reinstating him. That's not something that's that she even can do. And yet she did it. And it went up to the DC Circuit, and 2 of the 3 judges on the DC Circuit panel upheld that. And so now that's why we're at the Supreme Court.
Wow. When's it going to be heard?
Lickety split. I can't tell you exactly when, but within less than a week, there've been the acting Solicitor General Sarah Harris filed the petition. There's already been a response. I think we filed our amicus brief within about 2 days after that.
Wow.
Working all weekend on it last weekend, and so I think that they're going to be Johnny on the spot here, because remember the TRO expires in a fairly short period of time. So. In fact, that's what Dellinger said in response is, the TRO is going to expire pretty soon. The Supreme Court doesn't have to worry about this.
Who was the TRO against? Trump or the
Well, so that's a great issue as well, because
Who was restrained?
Yeah, you're not. The district judge is not allowed to restrain the president, and so they said that they were only restraining lower officers. The problem is there is no lower officer. There's nobody between the president and this person that he fired. So they really did restrain the president, even though they didn't admit that that's what they were doing. And in fact, that's one of the issues that Judge Katsas, who dissented from the D.C. Circuit panel, pointed out. And he said, wait a minute, you're saying that you're not restraining the president, but you really are. And Danny, you'll understand this. If this power were upheld, if district judges could do this,
they're the president now.
Well, they would have all this power to put TROs in over and over and over again.
Yeah, and they're appointed, not elected.
That's right.
And they're accountable to no one.
That's right. So,
and it would take a 2/3 vote of the Senate in order to remove them.
Yeah, well, that's another case we have, but we'll talk about that some other time. But yeah, absolutely. You would be empowering these district judges to interfere with the president's operation of the executive branch. And our founders wanted
and now you're getting into political questions.
Absolutely.
Which is also not permitted.
It's not. And our founders wanted that executive force, that ability of the executive to act with dispatch is the word they use, but we would just say act quickly and efficiently, which is what President Trump is trying to do. And here's a district.
He is definitely efficient. he's definitely acting.
He's very active. He's very active. That doesn't seem to be a problem. But like I say, the Supreme Court's already ruled on basically this exact issue. And so for the district court to hold him up on this, I think hopefully it's not a taste of what's to come with some of the other pending cases. But that's my fear.
I think that's the last line of defense that they have is lawfare. That's what they've been trying to do with Trump since 2015.
Yeah. I think that's right, and I think that we'll have to see if the Supreme Court is willing to jump in here and clear this up. I think that they will be. I think that they recognize the stakes here as well, and that if they clarify that you can't get a TRO against the president, you can't stop the president from firing somebody, at least if they're a principal officer. You can't put the other thing that this judge did is, as she put in what's called an administrative stay. So this was before the TRO even went in. She said, well, I haven't had a chance to read the papers yet, but I'm going to put in an administrative stay so that, Dellinger gets to keep his job while I'm sort of reading the papers. Well,
why would you do that?
Well, it's not a thing.
The lesser of the evils is let him make money, if anything, but you don't give him the power.
You don't give him the job
Not against
back.
the president of the United States.
Right. Why would you assume that the person who got fired is the one who, has the better argument? But administrative stays are something that judges or that courts rather will enter against each other. So, for example, they might issue a ruling against you and then say, well, we're going to administratively stay this for 30 days to give you a chance to appeal, that kind of thing. That's what administrative stays are. They don't run against the executive branch. But here you had a district judge entering a so-called administrative stay against the executive branch. That is not a thing. And I want to give a hat tip here to Josh Blackman, law professor at the Volokh Conspiracy at Reason.com, who brought this issue to my attention and I think makes a very strong argument that there's an abuse of administrative stays going on here as well. That's a little bit in the weeds, but it's an important abuse of power, I think.
So how did you get involved in this, and what's the organization that you're working with?
Sure.
How did that happen?
So I run a group called the New Civil Liberties Alliance. We've been around a little more than 7 years now, and our full-time job is to protect people's civil liberties from the administrative state. And here, it's a little bit with the shoes on the other foot, because you have the president trying to control the administrative state, and the administrative state's fighting back.
Yeah.
And so we're jumping in with an amicus brief at the Supreme Court on the side of the president, saying, no, look, in this case, his legitimate power is being thwarted, and we don't want to see that happen either. So we had about 7 cases at the Supreme Court last year, and victories that we had at the Supreme Court last year. And this, as I say, this is an amicus case, but because it's happening so quickly, not that many organizations were primed to jump in and file amicus briefs. So hopefully,
how many have there been?
I've only seen one other, but I haven't looked at the docket today.
Was it a valid brief?
No, I don't think it was. It was filed by some law professors at Columbia University Law School who were trying to essentially scare the justices about, well, what would this mean for the Federal Reserve if the president can fire direct reports? And so that was the issue that they were introducing. I think one of the things that one of the arguments that I've seen,
can the president remove the chairman of the Fed?
I think it's a tougher question. That's a multi-member agency, and the court hasn't spoken to that question in a long time on multi-member agencies, the way they have with these single, individual headed agencies. But I definitely don't think that the court should be making that kind of momentous decision in this sort of super tightly constrained TRO case. And so what one of the commentators I read said about this is, look, Trump didn't cause the emergency here. Dellinger caused the emergency by suing for a TRO, and then the judge caused the emergency by granting the TRO. Yeah. What should happen here is what we were talking about before, Dana. You brought this up, that he should be suing for damages. There would be no urgency in that, and you could allow this to play out on a much more reasonable timeline. Yeah, and give the justices the time, and the lower court judges too, but give them time to really put their brains around this question. But this one's an easy one, so I don't think it'll take them that long to get to the right answer.
It'll be fascinating. We're definitely going to keep up with it, and
fantastic.
We'd love to have you back. And even if you, where are you out of?
So we're right here in the DC area, New Civil Liberties Alliance, nclalegal.org. If folks want to go to our website and learn more about the organization, we have sued the Trump administration before when during the first term.
What did you sue him for?
One of the things we sued him on was bump stocks, the bump stock ban, which we did not, and we were vindicated. That was one of our victories at the Supreme Court this summer, was having the bump stock ban overturned. And,
who actually was the lawyer that argued it?
At the Supreme Court, that one was Jonathan Mitchell, former Solicitor General of Texas. Like you said, come up from a Texas.
If you ever
court.
Need any kind of firearms case in front of the Supreme Court, let me know. I'm admitted.
That's your thing, huh? Okay.
Yeah. Well, I shot the most number of competitive targets in the world.
Oh, fantastic!
In American Skeet last year.
Oh, congratulations!
Yeah, thank you.
That's terrific.
I won two rookie world championships.
I love skeet shooting. I've never done it competitively, and I wouldn't do well. But
Well, if we can ever coordinate, I'd love to go out with you.
That'd be fun. I would enjoy that.
That's my thing.
Okay.
I do it a lot.
Oh, that's good to know. That's good to know. Well, we'll try to make that happen.
Thank you so much for being on the show. And
thanks, Dana.
Definitely want to follow up with you after this comes out and update the audience.
This
is the Lawyer Dana Show live from CPAC. We got more to come, so make sure you've liked, subscribed, turn the alerts on, and we'll be back here in just a few minutes live from CPAC, Washington, D.C., actually Maryland. But
that's right.
Close enough.
We're in Virginia.
Same difference. That's like saying we're from Dallas. We're really not actually in either Dallas